Good morning, everybody. Welcome to the most recent Greens List educational session for barristers and solicitors. This morning we're going to hear how to run a civil jury trial. Recently I was at an Australian Bar Association conference in Berlin, and a senior English silk told a story about how two of his colleagues entertained themselves when they were bored. They played a game in which the aim was to get a witness to say, "I didn't come here to be insulted." 1 point was awarded for achieving this in cross-examination, 2 if it was your own witness, and a bonus point was once awarded when an interpreter said it. And when he did, the judge said, "Oh really, where do you usually go?" Now, I'm not sure that's the best way to run a jury trial, but today we're going to find out how the best way is. When I started at the bar, the doomsayers were saying that the civil jury trials were going to finish soon, and they have done so ever since. We've seen many changes in the law, and nowhere as much as civil litigation, the source of most civil juries. Today, jury trials are alive and well, but so many of us are involved in pre-jury litigation, particularly serious injury claims, that it's useful to have an opportunity to carefully consider the steps that need to be taken to run a trial. We're very lucky to have 2 experienced speakers in this area. Aine Magee is a specialist personal injuries lawyer. She came to the bar having been a partner at Phillips Fox, as it then was, specialising in insurance. She's a member of the Supreme Court Personal Injuries Group and a genuine expert on the assessment of impairments, having worked with and lectured on the AMA guides to evaluation of permanent impairment. She's widely regarded as a thorough, competent and is much sought after in this field. Tsikaris also is a very experienced practitioner. She worked in personal injury litigation at Clements Hutchins, then Dunhill, Madden Butler, which became Deakins and Gaydens and Norton Rose and whatever. She was a partner in their various incarnations from 1998 until 2002. Prior to coming to the bar, she was also a senior legal advisor to the medical panels and practices widely in personal injury litigation for both plaintiffs and defendants. I'm sure their words will be indeed words of wisdom. Could you please welcome Tsikaris?
Thanks for that kind introduction, David, although looking around at some of the people in this room today, I think a few of you could probably teach me a thing or two about running a damages trial. I'm going to address this morning the evidence and the steps you take before you actually get to the door of court, and Aine will then take on from there. I thought I'd start with expert evidence, and most of you will have run many serious injury applications and originating motions, and having got to that step, you then need to consider, having got to that step, you then go on to your damages trial, and you need to consider what evidence you've got, your lay evidence, and then whether or not you need an expert that is going to be able to address a significant aspect in your case and deal with evidence that your lay witnesses can't, areas that your lay witnesses can't give evidence about. Now obviously the sort of experts you'd be looking at are in relation to quantum, and they're the sort of experts that you often see preparing reports in relation to economic loss, loss of earnings, dealing with the multipliers and superannuation. And Cunston Sargent, not that I'm endorsing them, but they often produce these sorts of reports. Sometimes you query their relevance because where you've got details of a person's pre-injury earnings and details of what a comparable employee would be earning, and you can get the multiplier, you really have to query the relevance of then having an expert give that evidence when you can call that lay evidence. The other field where you'd be looking at calling an expert would be in relation to liability, and that would be where there's something specialised about a system of work, for instance, or a piece of machinery, where you really need to get an expert to look at the system of work or the machinery, etc., and provide evidence having regard to that expert's specialised knowledge. The Evidence Act that was introduced in Victoria in 2008 deals with the calling of such expert opinion, and that's specifically Section 79. And Section 80 was introduced in the Evidence Act, which has basically abolished the rule relating to ultimate issue and common knowledge. So often a basis prior to the introduction of the Evidence Act in Victoria, a basis for opposing the introduction of expert evidence in relation to, for instance, liability, would be that the expert was going to give evidence in relation to the ultimate issue that the court was there to determine. The expert had reached conclusions as to a breach of duty, etc., but that ultimately is the issue for the court to determine, not for the expert. Having regard to Section 80, that common law rule has been abolished. Nevertheless, the court does retain a discretion, a general discretion under the Evidence Act to exclude evidence which might be prejudicial, confusing or misleading, and possibly result in the waste of the court's time. The position regarding admissibility of expert evidence was canvassed in the landmark case of McPhee and Sprowls. It's a New South Wales Court of Appeal case, and the citation for that is 2001, New South Wales Court of Appeal 305, and it looked at the New South Wales equivalent, Section 79 of the Evidence Act. And essentially what the court said, for evidence to be admissible as expert evidence, firstly, it must be demonstrated that there is a field of specialised knowledge. There must be an identified aspect of that field in which the witness can demonstrate some training, study or experience. The opinion must be based on that expert knowledge. So far as the opinion is based on facts observed by the expert, the facts must be identified and proved. If facts are assumed, they must be identified. There must be a proper basis for forming the opinion. The opinion must demonstrate the expert's basis for reaching a conclusion and how the witness's expertise applies to the opinion propounded. Now, there was a recent case in the Victorian Supreme Court, decision of Justice Emerton in Ferrugia and Dindi Warrabak Children's Centre, in which these provisions were considered, and in that case, expert opinion from an ergonomist was sought to be called regarding the risk of injury to a plaintiff required to cut cardboard repetitively using what was termed poor quality scissors. Now, in that case, the defendant objected to calling any expert evidence basically on the basis that there wasn't a body of specialised knowledge about the risks of using poor quality scissors repetitively. And also that the risk was, it was maintained by the defendant, that the opinion would ultimately usurp the functions of the trier of fact, being the jury in this case. What had happened in that case is that the expert had read the medicals that had been supplied by the parties, interviewed the plaintiff, and then examined scissors which were said to be similar to those used by the plaintiff. So the expert didn't even inspect the actual scissors. And the defendant said, well, essentially what the expert's trying to say is trite, there's no particular scientific basis to his conclusions, and the jury might be overly affected by an opinion given it was cloaked with the mystique of being given by, the evidence being given by an expert, and thus they would be unduly influenced. Ultimately, Emerton permitted the witness to give evidence on the basis that the witness did in fact have some specialised knowledge, and some of the evidence went to this specialised knowledge, although she said it was albeit scantily. There was also another case that was decided along similar lines in the Victorian Supreme Court last year, and that was Rees and Lumi Christie Primary School. Magee and Sproul is New South Wales Court of Appeal authority, but there has been a recent case in the High Court of Das Reef and Horcher, and that's reported at 2011 High Court Australia at 21, and that considered the admissibility of expert evidence in relation to the inhalation of silica dust, and it basically approved the reasoning in Magee and Sproul, and the position of the court was that the evidence was inadmissible because the expert did not explain what elements his training or study or experience led him to possess the specialised knowledge which enabled him to reach the conclusions in relation to the amount of silica dust that was emitted when grinding stone. And the expert couldn't explain how he'd reasoned from his specialised knowledge and reached the conclusion that he had. Order 44 deals with the procedural aspects of exchanging an expert's report. So once you've made the assessment that you need the report and you've obtained the report, Order 44 deals with the issue of service, and you've got to serve the report not less than 30 days prior to trial. Often there'll be court orders that require service of expert's reports prior to that date, but if obviously you've obtained an expert report after the expiry of a court-ordered date, you need to serve it as soon as possible and certainly no later than 30 days before trial. And the risk of not doing that is that you can't adduce the evidence, or that if you want to adduce the evidence, you might face the cost of an adjournment. And of course, getting an adjournment's no guarantee. When in obtaining your expert witness report and you instruct your expert witness, you have to provide the expert witness under Order 44 with the expert code of conduct. The actual form of the code of conduct is in the rules. It's under Order 44. And essentially, the expert must agree to be bound by the code of conduct. And the code provides that the expert has an overriding duty to assist the court impartially on matters relevant to the area of his or her expertise, and that the witness is not an advocate of the party. Bear in mind also that once you serve the report, even if you don't intend using it, it may well be that the other party will use it and they can tender it and put it into evidence. Goes without saying, but make sure the report's signed. There have been instances that I've seen where reports not been signed, and also there have been instances where you can't actually determine who in fact prepared the report and what the relevant expertise of the author of the report is. And that sometimes happens when you get two people signing off on the report. You need to be able to identify the expertise of the expert who prepared the report, and they need to sign off on it. If you get a supplementary report, serve that forthwith. Again, if you fail to do that, it might result in you not being able to use the report or either the supplementary report or that initial report without the leave of the court. Excuse me. Another step that you need to consider about taking in a damages trial is a view. Now, it can be undertaken either during the pre-trial stage or during the trial stage. If you haven't undertaken a view during the pre-trial stage and the parties, one or other or all of the parties, advocate for the court to view a system of work or premises, make sure you go out there before the court actually does, because you don't want to have any surprises. The court has an inherent discretion to hold a view during the conduct of a trial, and even if the parties oppose holding a view, they can have, the judge can order a view. It used to be the position that the purpose of a view was to enable the court to understand the evidence, and the actual view wasn't the evidence, but with the introduction of the Evidence Act, specifically sections 53 and 54, that's changed, and a court now and a jury can draw inferences, any reasonable inferences from what they see, hear or otherwise notice during a view. And David was just telling me this morning that he was involved in a case where they had a view, but what was involved was a reconstruction of the circumstances alleged by the plaintiff. And what he can tell you all a bit in much greater detail, but what ultimately emerged from such a reconstruction was what was alleged by the plaintiff couldn't possibly occur. Is that correct? Yes. So it's very instructive to have such a view. Certainly at a pre-trial stage, you can have a view to work out yourself if what's being alleged by one of the parties or your opponent is in fact what is capable of occurring. And plaintiffs often have their expert attend a view, so the expert can provide an opinion as to a system of work or the machinery, etc. In those circumstances, if the other side is wanting to inspect or have a view at your client's premises, make sure you have a legal representative attend the view. A view is not to take place to enable the plaintiff to engage in a fact-finding mission. They're not an engineer or the expert, etc., is not entitled to interrogate or question your client, and the inspection or the view ought to be of what's been pleaded as the system of work or the premises that were faulty or defective or whatever, so that the view is confined to matters in issue in the pleadings. Next, discovery. Under the Accident Compensation Act, a lot of the documentation will have passed between the parties by virtue of the pre-litigated provisions under Section 134AB, but there's still a place for discovery in a damages trial. Often additional documents will be uncovered as you're preparing for trial, and you've got an ongoing obligation to discover those documents. If the other side's pressing you for documents of a particular type and your client says, no, I don't have them, I think dig further, because experience often tells you that if the other side is saying your client should have these sorts of documents, they probably already have them themselves and they want you to find them. The Civil Procedure Act that was introduced in 2010 also specifically provides for the continuing obligation to disclose documents, and disclosure under the Civil Procedure Act is now one of the overriding obligations, and you have such an obligation under that Act to disclose the existence of all documents in your possession, custody or control, which you're aware of or you might reasonably consider to be aware of, which are critical to the resolution of the dispute. So not only do you have an obligation under the rules, it's now an obligation under the Civil Procedure Act. There are instances where obtaining documents can either make or break your case, so it's really important to ensure that there's been compliance by the other side. You can tender documents that have been discovered. You can use the documents to impeach the other side's witnesses' credibility. So it's very important to focus on your obligation to undertake discovery and hunt down those documents. The general principle, though, is that the documents that you do obtain in discovery, you give a general implied undertaking that the documents will only be used for the purposes of the proceeding unless you get the consent of the owner of the document or the leave of the court. And you'll find the TAC routinely asked to be discharged from this implied undertaking at the conclusion of a serious injury application so that documents can be used in any subsequent proceedings. So you have to be mindful that documents that you've obtained in proceedings, you're undertaking not to disclose them in other proceedings unless you get a release from that implied undertaking. In terms of the timing of discovery and interrogatories, it's important to get discovery of documents before you interrogate, because there might be documents that give rise to the existence of facts or the knowledge of facts which you want to interrogate on, or you might want to interrogate on actual documents. So if you're briefing counsel to prepare your interrogatories, make sure you include the discoverable documents in those in your brief. So interrogatories can be exchanged, can go to addressing those documents if need be. In terms of interrogatories, you need to look at what's relevant. If your claims for general damages, don't interrogate on echo loss. I know it sounds obvious, but it does happen where people try and seek to interrogate in respect of other issues. It's important to get a party and pin them down to a version of events, and that's why interrogatories are very useful. You can get admissions, which ultimately can be tendered in evidence, and if a witness gives inconsistent evidence to the answers to interrogatories, their credibility can be attacked. So it's very important, in my view, to interrogate. If you have interrogated the other side, look at your answers. Don't be satisfied with, I'm unable to say as an answer. There has to be a proper basis, and you need to articulate the basis for saying you can't answer a particular interrogatory. So if your answers aren't adequate, press the other side and consider the issue at a time that you have ample opportunity to ventilate the argument as to the adequacy of the answers. Often, as a busy practitioner, you've got the answers and you've had a look at them and you think, right, and then as you're preparing for trial months later and the trial's imminent, you look at them and upon reflection you think, I should have really pressed something. And it's often not too late, but sometimes you really run out of time in obtaining or being in a position where you can compel proper interrogation and proper answers. Okay. Finally, in terms of witnesses, don't just be satisfied with an investigation report, particularly where you've got witness statements where they're still in draft and they haven't been signed. You need to interview the witnesses yourself, and I think it's important to do it early. The evidence that you're going to call will be based on the statements and the evidence that you've got from these witnesses. And if you have to make admissions, you need to do it on the evidence that you glean from these witnesses. So you want to be able to get a proof of evidence from these witnesses, because you don't want to be in a position where you make an admission and then ultimately you've got to withdraw an admission. You might be able to withdraw an admission, but it exposes your client or a witness to cross-examination as to the basis upon which an earlier admission was made. In certain circumstances, you might be able to tender a document or a statement that's been made by a witness without calling that witness, and sections 63, 64 and 67 of the Evidence Act deal with those circumstances where a witness might be unavailable, for instance, or where it would cause undue expense to call that evidence. And the examples that are given is where someone's given a statement in relation to an investigation of an accident many years before the trial of the proceeding. When it comes to preparing for trial, that witness cannot be located. You can give notice, and it's under section 67, it's reasonable notice to the other side that you intend to adduce evidence by tendering the statement, and the notice provision allows that the other side can object within 21 days of giving that notice, because they might be able to make their own inquiries about calling that evidence and finding or locating that person, as an example. In terms of witnesses, before your trial starts, you'll be asked to give a list of witnesses, and that'll be all the witnesses potentially that you might be calling in a trial. That's your lay witnesses, your expert evidence, expert witnesses, and your medical witnesses. And the purpose of doing that is to give the judge an indication of who is likely to be called, and when a potential jury pool is brought into court, the judge will give a summary of the case and also tell the potential jurors who the likely witnesses are going to be. And that enables a witness at that stage to seek to be excused from giving evidence on the basis that they might have knowledge or know one of the witnesses. So it's important to be as expansive as possible in terms of your list of potential witnesses, because you don't want to be in a position where you want to call someone, they weren't on your list, and they're known to a juror. I mean, it could derail your case, and it's a very expensive exercise. It goes without saying that you don't want in a position where on day 6 or something like that, you're calling someone and the case has to be aborted because a juror knows a potential witness or something like that. And if you do have witness statements from investigators, etc., and you have obtained proofs, they don't go in your court book, because the evidence in a damages trial is oral evidence and it's not by way of statement or affidavit. So that pretty much brings me to what happens when a case starts, and I think this is where Anya takes over. I think I've finished 5 minutes short.